Hi everyone, we're going to wait for another minute, give some time to everyone to attend. Okay, a few more seconds. The numbers are still going up. Okay, let's make a start. Hello and a very warm welcome. Thank you for joining our panel discussion on how experts and lawyers can best work together, the challenges, the opportunities, and possibly time for a change. We're going to discuss real-life examples from our experience of the use and abuse of experts from the three perspectives of the instructing counsel, the advocate, and the expert. Our event will last an hour. It will be recorded, and the recording will be available next week. We're going to try to leave 5 minutes at the end for Q&A, so please feel free to ask questions as we go along using the questions button on your GoToWebinar panel, and I'll keep an eye on them and distribute them to the panelists at the end of the discussion. So let me start by introducing our panel. Roberta Downey, our instructing solicitor, heads the global construction and engineering practice at Hogan Lovells. She has 30 years experience in commercial dispute resolution, including large trials and highly technical disputes arising out of power plants, LNG facilities, engineering support services, rail infrastructure, telecoms, wastewater treatment and recycling facilities, and automated equipment and control systems. Rachel Ansell, QC, our advocate, is with Four Pump Court. She has over 25 years experience. She has a general commercial practice with particular expertise in construction and engineering, energy, professional negligence, and insurance. Her large international arbitration practice focuses on large-scale energy, construction, and engineering disputes across the globe, and particularly in the Middle East, where she is registered as an advocate at the DIFC, the Dubai International Financial Center. My colleague Karen Best is a principal at HKA in London. Karen is a chartered civil engineer with 25 years experience in the construction and engineering industries. She worked as a site agent and senior engineer for almost a decade before moving into construction consultancy, which gives her a strong grounding for the delay expert roles that she has taken. And finally, my name is Roula Harfouche. I'm a partner at HKA in London. I specialize in the assessment of damages and complex valuation issues in litigation and international arbitration contexts, including commercial and investment treaty arbitrations. And I'm the only non-construction specialist on the panel. So let's start with our first topic. We're going to discuss best practice and things that go wrong, and we're going to do it in the order of the involvement of experts in disputes. So we're going to start with the selection of experts. Karen, do you want to start us off?
Yeah, sure. Thanks, Roula. So we're talking about the selection of experts. I think the most important thing is to check that the expert has availability for all the aspects of the case. They have to have availability to do the analysis, to write the report, and to prepare for, as well as attending the hearing. Whenever there's a complex analysis, delay analysis often involves using assistance, because you need assistance to get through all the data and to properly review all the documents and carry out the analysis. However, you want to check that you're getting the expert, not just the assistants. You need to understand that the expert themselves have sufficient time to direct and supervise all of the work, to have gone through the documents, and to fully understand and know the detail and the documentation, and that the opinion is fully theirs and that you're not getting the opinion of their assistants. It's also really important to know that the expert has time to fully prepare for the hearing, because the expert needs to know the report back to front whenever they're giving evidence and being cross-examined. Another aspect that's really important whenever you're selecting the expert is obviously that they have the right expertise. I think it's good to provide the expert with some information in advance of an interview, and they've got some time to review that documentation. Then whenever you interview them, you can thoroughly challenge them on how they go about their analysis and what their views are. And also you can test them under questioning to see how they respond. And that'll be using the real examples of the documentation that they've reviewed. So Roula, I'll hand back to you.
Thank you, absolutely. I'm going to be a bit contradicting you for a second, but I would also suggest that you ask to meet and you interview the experts team, or at least their main support person, and ensure that you're satisfied with their quality, because the busier the expert, the more you'll be dealing with their team. And also, it's worth checking that the expert genuinely holds the views and holds views that are likely to benefit the client. Now, I know this is not relevant for delay or construction generally, but it is very relevant for valuation or damages assessment, because valuation is not a hard science, it's a social science, and there are a number of topics that are not settled within the profession. So you want to make sure that your expert holds views that are either good for the client or not bad. Roberta, what does the instructing solicitor think about when selecting an expert?
Well, this particular instructing solicitor, as those of you who know me will testify, likes to have her cake and to eat it. So I want the expert. I need to know that when I interview and engage the expert, I am actually going to get the expert, and he's not going to subcontract all the work to the team and disappear a bit, as Karen said. But on the other hand, I also want the expert to have the team, because I want to know that if they need to expand and put more resources on, they've got the ability to do so. And sometimes, of course, it's also more cost efficient to delegate some of the work. And when we come to trial, I also want to have the experts team to be able to explain to me what the expert is saying, particularly if it goes into areas which we haven't explored. So that's the first one, that you want the expert as well as the team. The second one is I want an expert who's honest. I find that, like lawyers and perhaps like everyone, there are two types of expert. There are those who will tell you what they think, and there are those who tell you what the client wants to hear. The problem with the latter is that it tends to go one of two ways towards the end. One is that they either wobble and collapse before trial and then start distancing themselves from the case and even abandoning large sections of their report and making concessions, at which point it's very late in the day for the client to do anything about it. Or the second way is they tend to stick to really unrealistic positions to the very bitter end and come across as partisan or lose all credibility. In which case you then end up having no evidence because the tribunal will just put a line through the whole lot. And the third thing I look at when I'm, which is new, which I look at when I'm engaging experts, is I do go through the law reports and see what tribunals have said about them. So because it will be put to them in cross-examination. So that is very important. And I know it is something that makes some experts shy away from giving evidence in court as opposed to arbitration.
Yes, absolutely. Rachel, what does the advocate think about?
Thank you. Well, I think I agree with most of what has been said. I mean, I think in terms of the team, what I see as useful as an advocate is the team can be very helpful in the preparation of a claim at the very early stages, because it keeps the main expert away from that claim preparation and ensures the independence, which is very important going forward. However, as Roberta says, the team is not a replacement and can never be a replacement for the expert. And I've had experiences, as I'm sure Roberta has, but the one that sticks in my mind was an expert who'd obviously subcontracted out his or her, I should say, report. I picked up the report. It was provided to me by a courier at Heathrow Airport because I was flying out for the hearing, which was due to start in 3 days' time. While I was reading the report on the aeroplane with a glass of champagne in my hand, even I was able to notice that the calculations were just wrong as a matter of arithmetic. And you can imagine 3 days before a hearing starting, that is not ideal. So, and it just goes to show you've got to make sure that the expert is properly engaged. I think, so, as Roula said, it's probably different with valuation evidence about finding out what your expert's view is and checking it sort of coincides with your client. Certainly when it comes to technical evidence or programming evidence, I want to know what the truth is from the start. As Roberta says, you need an honest witness. But I think the most important thing, which I think has been picked up as well, is expertise and making sure you've got the right expertise. And if you haven't, either you've got to say honestly that you haven't got it, or identify the particular issues in respect of which you don't have the expertise, so the gap can be filled. Because if you don't, all that will happen is the issue will come out later down the line. Now, you might be lucky and it comes out at the sort of pleading or stage or the expert reports, but that's just going to generate more costs because experts have to be brought in at that time, pleadings have to be amended and the like. My experience, it normally comes out during trial, as Roberta says, at which point your client can do nothing about it. Firstly, me as an advocate, I'm hampered because I can't properly cross-examine the other expert because I don't have the necessary input, and inevitably it will come out in cross-examination if they don't have the right expertise. And so I guess my tip is, from a commercial point of view, it's better to lose one set of instructions than to end up giving evidence in court or in a tribunal where you do it very badly. As Roberta says, one of the things we all look at are law reports, or do now, but I'm sure Roberta will agree that there is also a lawyer's grapevine. And if you know an expert has performed badly, you will make sure that they are never on your case or any of your colleagues again. So that's my tips on the selection of experts.
Brilliant, thank you. Our second topic is linked to it. So it's best practice and things that go wrong with the early stage, or the investigation stage of the appointment of an expert. Karen, can you start us off there?
Sure. So I think it's really helpful to get the expert to do some preliminary work, give them the documentation and ask them to come away and do an independent preliminary assessment of delay, for example. I think that has lots of benefits because usually you come up with your preliminary opinion, which might be that really there's no merit and therefore there's no point pursuing the case. That might be the worst case. Or it might be with, I've got examples where, you know, you can see that there's no entitlement to extension of time, maybe in the construction phase, but actually there is entitlement in the commissioning phase. So that might be the element that you need to focus on. And again, that's helpful to know that as early as possible. It also helps to identify gaps in the information. In my experience, getting the right information, especially for delay analysis, takes a really long time. You have to find the right people to talk to pin it down, and you have to go away, and they have to go away and do quite a lot of research finding the information. Usually it takes several times of asking before you get the same information that you asked for the first time. So the earlier you can put that request for documentation out, the better. It's also really important to get as much information as possible towards the start of any analysis, because taking account of additional information into account whenever you're partway through the analysis, whenever you're 90% the way through the analysis, just ends up being more time and more analysis, and it's more inefficient and costs more and takes more time. The other thing that I find really important for me is I really want clear instructions about what is required and what expertise is required, because sometimes that isn't known at the beginning, but the earlier that can be given, then the easier it is to identify those gaps in expertise that Rachel was talking about. So that would be my plea for clear instructions early on. And then also, if you've been able to carry out that preliminary review and preliminary assessment of the documents, you should be in a good position to give a budget for the case. And that's really helpful for us as experts, but also obviously for the client to know where they are. That's my view. Roula, you've got other thoughts?
Absolutely. Other thoughts. At the very beginning, this is a good time to iron out any inconsistencies. That's between, on the one hand, the theory of loss that counsel and the client are developing and the arguments that they're using. And dare I say, the amount of loss that's going to put into the request for arbitration. And on the other hand, the expert's view on the likely loss and the rationale for that loss. I've seen horrible cases where we got involved after the amount was put into the request for arbitration and there was no way we could support it. This is also a good time to define and refine and debate the but-for scenario, which is often the most controversial bit of our work. Now, once your expert is involved, make full use of them. So get them and their team to review and comment on the relevant parts of the submissions. Get them to assist with drafting and responding to disclosure requests. So they'll often know what information is there and what's the best way of phrasing the disclosure request so that it is respected. Identify also the right employees at the client to talk to, and also review their witness statements to make sure that they cover what they need to cover. And finally, this is going to be a bit controversial, but listen to and discuss with the expert any objections they have to arguments you're making or planning to make, because their view from their different perspective will help refine and strengthen the arguments. So it's much better to debate them within the larger team, including the expert, than to discover them coming from the other side. Roberta, what do you think about in the early stages?
Quite a lot of the comments that Karen made, I also see from a different angle. On the documents and data one, the point I would put to experts is really think about what you really need. What would be sufficient rather than what you really want. So many experts give you this huge shopping list of every single document on the project. And if I found that particularly with technical experts, the more PhDs in the room you get, the more different opinions and the more data they seem to want and the continual testing. And the reality is it's a bit like engineering. You don't need to build the golden staircase. The case just needs to stand up to scrutiny. And if you do more, you're over engineering, just like engineers. So really think about what you need. The courts and tribunals are moving away from the sort of old style Peruvian guano, every single document of the case. I think experts need to as well and be prepared to give a view based on the information they have. So think about what's sufficient rather than everything you want. The second one that I also pick up on from Karen is the budget. I and my clients tend to be a bit like Don Corleone in the Godfather. If you've got bad news, I want to hear it straight away. So if the budget and the quote you gave to win the job is not realistic now that you've got an informed view, now's the time to re-baseline and revisit it. And then the third one I would probably say is recognize the role of the expert. The expert is not there to invent and create a case that can't be backed up. They're there to help present the case as presented in the documents and as explained by the people on the project who were actually there. So experts can be a tremendous resource. They can help you grind through masses of information and data and simplify it and distill it and help you to present it. But if you over rely on them to create a case, it all falls apart because the reality is you've got to build a pyramid, and the bottom of the pyramid is the documents, above that are the witnesses, and above that is the expert. If you try to do it the other way around and you're building it so that the bottom is the expert's created case, you're building a funnel rather than a pyramid, and it collapses.
Absolutely, totally agree. Rachel, what are your views on this?
Yeah, well, it's a bit different for me because I tend to come in rather later than this stage, or certainly more recently. I agree with all of you that I think we certainly need experts on board early, because as the advocate, it is much easier to argue your case if the proper case theory appears in the pleadings, rather than having to amend it and then put a slightly different case when it comes to the actual advocacy itself, and can lead to some quite uncomfortable conversations. So for my part, I certainly agree with that. I think the other thing is that I agree, Roula, about the thrashing out of the case early. But within that, and this is a bit of Roberta's point, you do get some experts who say what the client wants to hear. But whatever the client wants to hear, I can assure you what I want to hear are the weaknesses of the case as soon as possible, or the issues with the expert evidence as soon as possible, because one, together you might be able to find a way through it, or two, you just pick your battles. And what every client does not want to do is fight an expert issue on which they lose, because that just tarnishes the rest of the evidence. So for me, the early stages is that. And I think from a programming point of view, and Karen, I'm sure you've had this before, is the client has put in applications for extension of time and is absolutely convinced that, I don't know, access to the site or late handover of a particular piece of was causing all the critical delay. What we need to know pretty quickly is whether that's right or wrong, because in my experience, quite a lot of these EPC contracts, procurement is where it's all at, and again, that's something you need to know. Otherwise, there's a complete disparity between the case and where we end up. So I think that's my only 2 points as an advocate.
Brilliant, thank you. I'm going to contradict myself and ask a couple of the questions from the audience, because they're brilliant. So the first one is, in selecting an expert, how important is it for you that the potential expert has testifying experience? So if they've got the technical and other expertise, but they haven't testified yet, is this a no then?
Shall I start? I've used experts who have never testified before. There's always a certain amount of nervousness when you do so. So it's a bit like, when a child's learning to swim, there comes a point when you have to take the armbands off and see if they can actually swim. So there is a bit of a leap of faith, but I would much rather, and this is why I chose that particular expert, have an expert that knows what they're doing, and in a way is hungry and knows it's their first chance, so will do all the work and prepare, than to have one of the experts that you sometimes get with the big name and the reputation, who actually just swoop in for the hearing but haven't done any of the work. So if I had a choice between the two, that's what I would choose. I would choose the young, hungry one who hasn't testified. What I did do with that particular expert is you might put them on one of those Bond Solon courses, so that they at least have some experience of what it will be like. But everyone has to start somewhere, and I'm keen to do it. I probably wouldn't normally use someone with So Green on a bet the company case. But I have used them. I normally, in that situation, will put them with the big names so that you have got a team. But I find actually that it's much more important to have someone who's going to do the work and who's hungry and will do the prep than to have a testifying expert who doesn't have time, yeah, or is past that stage in their life when they're prepared to make the time.
It's I've seen it done in arbitration, obviously not in court, where you have two experts, one very experienced and one greener, and they split the report, and the greener expert will focus on areas of details. They're into everything, and the more experienced expert will just come in from time to time on high level stuff, and that gives them the opportunity to tick the box and say I've already testified. The second question is more, I'm going to direct it to Rachel now. The experts that are criticized in TCC judgments, what's your view on those individuals and on giving them a second chance? It could be considered that it is, after all, just a view of one individual, the judge, that they misbehave.
I think that's a really interesting question, because one has had experience of experts that you trust and use, and you see a judge that's took against them for a reason that you can't understand. I think you have to look at the criticisms that were made in the particular judgment and see what they were, because sometimes it becomes quite clear that the expert just hasn't been properly managed, and therefore it should be possible to explain that and for the expert to not get flustered by that in cross-examination. On other occasions, if what is in the judgment is this person was past exam, didn't have the necessary experience, or a very obvious criticism that it's going to be difficult to explain away, then I think it becomes much more difficult. But as I say, I think you have to look at each of the judgments to really understand it. I mean, I think the other thing is as well, and I'm not going to name names, but those of you who've been probably doing it as long as me would know that there were some judges who seemed to just find it a sport to pick on experts, and you probably took those judges' criticism slightly less seriously than others. I don't think we have that quite so much now, but I perhaps should say no more since this is being recorded.
I agree with that. I think you look at who's actually said it, but I think the mood of the courts and tribunals now have moved away from having a go at experts because they know it can have such catastrophic effects on their career. But the risk of that means that, for me, if somebody has criticised, they've clearly felt that the expert has stepped way out of line. It's not just a sort of sailing close to the wind, it's actually crossing lines. And so I'm afraid it wouldn't be an absolute bar, but it would certainly take a lot of convincing to get me to use an expert who's been badly criticised by a judge. And again, it depends what the judge has said. I remember once saying to a silk, there was a problem with our witness because our witness was currently in prison. And the silk said, well, what's he in for? And I said, well, he's in for sexual offences, for rape. And the QC said, well, that's all right then, it's not a dishonesty offence. So, if so long as the witness is not being criticised for dishonesty, it seemed to be okay.
An honest rape then, great. Well, thank you for that. Our third topic is best practice and things that go wrong with the next stage, which is the expert reports. Roberta, do you want to start us off on that?
Yeah, on expert reports, again, I come back to what's the role of the expert. And the expert is not to decide what factual evidence is right. That's the judge's role. So when you're writing your reports, you do have to take into account all the factual evidence and not just your side's factual evidence, and give it a fair hearing and not try and say, well, I think he's right or she's right or they're wrong. My second point is relevance. You've got to stick what's actually in issue in the case, rather than what you think should have been an issue or what you should have been asked or what's of more interest to you. So stick to what's in the case, and that should be defined in the pleadings. Certainly by the time you're putting your reports in, there may be amendments afterwards, but also hopefully you've been given a list of issues from your instructing solicitors that match what has arisen out of the pleadings. My third point is a really big plea, which is length. I can't bear 1,000-page reports. I've had some tribunals say to me that realistically they can't read more than sort of 20, 40 pages. So it's the old Winston Churchill adage, which is it takes 10 minutes to write a 3-hour speech, 3 hours to write a 10-minute speech. So if you give them a 1,000-page report or an overly lengthy report, the tribunal is just going to think, well, you haven't prepared this, you've just thrown everything in. And there's a danger, again, with relevance. You've not focused on what actually matters, what's going to move the needle. You've just thrown the kitchen sink in and left them to try and do their best. And I can tell you what will happen is that it gets put on one side. The chances of a tribunal ever reading a 1,000-page report, I think, are remote. To reading it more than once and really taking in, even more remote. Final one, don't hide behind jargon. I know it's complicated, but the people in the construction industry who are trying these cases as arbitrators or judges do know a lot about engineering construction. They do know how Primavera works. They do know about critical path. And if you try and make it too complex and hide behind jargon and the tribunal doesn't get it, sometimes they'll just put a line through it. You're hiding behind the jargon rather than explaining it. Everything is capable of explanation, and you ought to be making sure that you're explaining it. So if you're a new expert and you want to try that out, you should try and explain it to somebody who doesn't know and see if they can understand it. And if they can't, you need to find another way to present it so that you can actually get your point across. Because there's no point writing them, you know, the thesis or the PhD or the Nobel Prize winning report on your particular expertise if no one can understand it.
Yeah, absolutely. A big part of our training is in writing clearly without jargon for non-specialists in the industry. Otherwise, it's a bit of a waste. Rachel, what do you think about expert reports?
I agree with what Roberta said. A few things to me is quite often I do get asked to review reports, getting them the day before they're due to be served, especially if they're one of the sort of 200, 300 pages, is of no use, because I just won't be able to take it in or give any proper assistance. So I think it's really important that, and I think this goes across the whole of the expert and solicitor and advocate teams working together throughout, is you need to have deadlines and you need to meet them. So you need to make sure you've got the date when the first draft's going to be, when you're going to get input back from everybody else, so that there's not that horrible last minute rush, which ends up in a dreadful error, you know, or when it comes to be scrutinised later. Sounds really simple, but this does come from the judges, and it's certainly something as advocates. Format, make it easy to read, headings, subheadings, but most importantly, paragraph numbers, not bullet points. Because if we're cross-examining you on or the judge is trying to find a reference, if I'm cross-examining you, it's on this page and it's this paragraph. Otherwise, it's on this page, and could we go to the 15th, you know, the 15th bullet point, which then everybody has to count down. So it sounds really simple, but it's something, one, that makes life easier for me as the advocate, but two, will be appreciated by the judge and the tribunal. And I think, you know, acknowledging what Roberta says about the lengths of expert reports, and I know for programming experts sometimes that's quite a difficult call if they're looking at a lot of different minutes and everything else. I think then what's important is you have a proper executive summary so that the big points are there. So in effect, the tribunal can read your opinion in the first, say, 20, 30 pages, if it has to be that long. And then everything else is, if you like, your support and backup for it. But in a sense, that's more for others to look at for cross, or just for you to be confident in your opinion. It isn't something the tribunal need to necessarily be troubled about. I think Roberta's put stick to the issues, but also in your report, one does sometimes find you've read 4 pages and you say, well, what was the point? What did that go to? What's that about? And that can be quite frustrating. And then always identify facts, assumptions, and as Roberta said, make sure that you take into account that the court or the tribunal might not accept your client's evidence. And if that's the case, you need to know what the answer is, just as importantly, if they don't. And I think, again, leave the advocacy to the advocate, if that's okay, and just concentrate, especially in your report. Don't concentrate on launching an attack on the other side just because you might have already done joint reports and think that your opposite number isn't very good. Much better to get your point across in a measured way. Any digs you want to make, possibly in a supplemental report, much more useful to me in my notes for cross, because it'll have more impact and you'll remain and continue to give the impression of being independent, which is obviously important. Okay.
Brilliant. Thanks, Rachel. Now, Karen, what do you think experts need from lawyers when it comes to their reports?
Yeah, I think reports are one of the hardest aspects. A lot of us come from an engineering background where we had no training at all on how to write well. So it was a bit of a steep learning curve, I'm sure, for lots of us to write expert reports that come across and put your opinion concisely and clearly. And I think it is really important to keep them as short as possible. Even me reading another delay experts report that's hundreds of pages long can be really painful. So I fully agree with reports being as concise as possible. I do find from the lawyers, again, going back to clear instructions early on really helps. Whenever instructions get clarified at the end and you've already set your report out one way and then you have to change it at the end, that can be difficult. It's also, I agree, it's really helpful to have lawyers doing sense checks or readings of drafts of the report at various stages going through. That's a real help to me anyway. I think it's also really helpful to be informed about any new facts or any changes in direction of the pleadings, and that isn't, come up as a surprise at the end, because that might affect how we write our reports, but depending on the facts, it might even affect our expert opinion. I also think it doesn't happen very often, but it happens on occasion, that the lawyers also have to remember that our independence is key, and to not try and push us to maybe make changes to our report or our analysis that would benefit the client, because we shouldn't do that. That's not our role. And we need to give our genuine opinion so that we're independent and that we're credible. I think sometimes that might be something I've come across more with lawyers who come from the continental side, because maybe that's a slightly different view of that. It doesn't happen very often, but when it happens, it's difficult because we have to just keep pushing back. And then the other thing is anything that we might have to rely on in witness statements. Again, it's really helpful if the lawyers can help in that process and understand the importance of anything that we're relying on being in witness statements if possible. Ideally, we're not relying on that and we're just looking at documents, but getting the lawyers on side and helping us with everything being in a witness statement is also really helpful. Roula, do you want to add your thoughts?
Thanks for that. I totally agree. I've had a couple of cases in which the lawyers didn't want to engage in preparing the fact witness statements or the exhibits to that, and so we had to do it. And on one of those cases, the witness removed a part of their witness statement on which we relied on the day of filing, and the lawyers forgot to tell us about it until after it was filed. So we had a horrible last-minute scramble trying to adjust our calculations, really, and our report. And this resulted, in addition to the stress and the risk of making mistakes, it resulted in a lower, in this case, damages figure, which then the lawyers and the client were disappointed with compared to the previous figure. So not a good situation to be in. I've had a recent one where there's local legal advice that came 2 days before filing the statement of defense. And this was a huge case. And that legal advice contradicted the case theory of the lawyers and the clients on which we based our but-for scenario. Again, serious scrambling at the last minute to update our report, the big risk of making mistakes. And also, we were not fully able to consider the implications of the new legal advice on damages. So anything you can do to avoid these situations would be great. So we talked about expert reports. There's also a different kind of report that we write, which is the joint statement. So this is where the two opposing experts in the same discipline meet and discuss the issues and then issue a joint statement. So these can be quite good because they help the tribunal or the court focus on the main and hopefully the most material points of disagreement. And I've seen them work very well when the experts agree on basic things, like, for example, for damages, if they agree on the valuation method, if they agree on the date of assessment, for construction, if they agree on the approach and the baseline. I've seen them not work at all and be of little assistance and be very costly when these basic agreements were not in place. So you ended up with a joint statement of 100 pages of disagreements. One point to note on joint statement is non-English counsel are often uncomfortable with them, and they think that we're negotiating with the opposing experts and on behalf of the clients, and we're going to strike a deal or something. That is not the case. That's not why we're there. We're just helping to set things out clearly for the court or the tribunal. in England as well, there's the guidance for the instruction of experts in civil claims that was issued in 2014 says that those instructing experts must not instruct them to avoid reaching agreement or delay doing so on any matter within the expert's competence, and experts are not permitted to accept such instructions. And that's why, in my experience, I think in England, joint statements work better than outside of England, where often I've seen experts, you can tell they've been instructed to disagree systematically. Rachel, what do you think of joint statements? Do you have some tips on those?
I think they're invaluable because they do just narrow the issues, and it's very helpful. I think in respect of programming in particular, for example, and Sir Vivian Ramsey, when he was sitting at in the TCC, he always used to get the programming experts to meet very early on to see if you could at least agree the methodology that you were going to use to measure delay, to avoid the 300-page reports from each one based on a different methodology, which were ships passing in the night. And it seems to me that there's still something to be said for that approach. In terms of actually preparing them, I always think it's important that the experts, and again, this may be something that you require from solicitors and counsel, is that you know what issues you're meant to be dealing with, so it doesn't go off topic, and so that you can be properly prepared and understand what issues you need to be discussing, so you've got an agenda. And my other tip is always make sure you keep a proper note of everything that you say and what your opposite number says, because obviously the discussions of what is agreed or not agreed have got to be recorded in writing, and it's much easier to do that if you've kept a note. But also on the odd occasions, where I'm sure it generally doesn't happen, but on the odd occasions where, contrary to the advice, there is some pressure put on experts, or when they come to discuss what they've sort of said in the joint meeting, opinions seem to change between that meeting and the production of the joint statement. There's obviously nothing you can do about that, but the fact that I will have knowledge that perhaps that wasn't the expert's first view or isn't the expert's view is going to provide me with very useful ammunition for cross-examination. So it does seem to me keeping those notes is very important.
Yes, great point. Thank you. So our fourth topic is best practice and things that go wrong with live evidence or given expert testimony. So I'm going to start adequately with Rachel, our advocate.
Yeah.
You
okay. Well, probably won't surprise everyone to hear preparation is everything. You've got to read your reports, the documents, and the party submissions. And look, I do include in that, because I've seen this happen a few times. Check your CV. Make sure it illustrates the experience that's relevant to the case. We all might have different areas, so we all might have different CVs for different topics. Make sure you've got the right one, and make sure it's up to date, because that is very, very important. Touching on what we were talking about earlier, if you are going to cite cases, make sure you know what the result was in those cases, because you know, people will do the exercise of just checking what has or hasn't been said if they haven't done it already. I know this sounds daft, just familiarise yourself with the trial bundle, because if the document doesn't look quite like you thought it did, or you haven't seen the setup of the electronic bundle, that can throw you off. Make sure that you're either hearing or reviewing in detail the transcripts of the live evidence, because you've got to take that into account. Assuming we ever return to live hearings, which I'm hoping we do, remember the old tip of answer the judge or the tribunal, don't answer counsel. So it's a tennis match. You look at counsel when they're talking to you, you look at the judge or the tribunal. It's really important. The judge is the only person, or the tribunal, the only people who matter, but also it stops you getting into an argument with counsel, which can happen, and is something we're normally striving to do to throw you off your sort of steps. Remote hearings have brought a slightly different problem to the one I've seen before, but it will apply when we're back in live hearings, is be respectful to the advocates and to the tribunal. Just because you're on telly and not in a formal room, or if you're in an arbitration, you're not sort of in court, don't be overly familiar. It doesn't come across well, and please restrain from using silly analogies. because again, it just leaves everybody baffled. You know, especially when it comes to technical issues and sort of tribunals that I'm in front of, they don't need things compared to a loaf of bread, for example, or a wooden floor, which are recent things that I've experienced. Also, be culturally sensitive. In one case I had an expert who decided to use 2 holy books, so the Quran and the Old Testament, to explain how a joint worked and then collapsed. That is obviously entirely inappropriate, and so probably should go without saying. Answer your questions truthfully, succinctly, KISS, keep it short and simple. That is the key to giving evidence, I think. Volunteer nothing. Make counsel work hard and ask precise questions. But again, don't try and be the advocate, because as soon as you start spinning things, it won't work. If you don't know, say you don't know. It's important you don't stray out of sight. If you get into trouble, just take a deep breath and get back on track. And if you think, I've got something wrong, I said something wrong, just correct it as soon as there's a pause. You can do that. It's not. So I think they're my main things about giving. That's a bit of a whistle stop, but they're sort of my top tips for giving live evidence.
Absolutely, thank you for that. Roberta, what are your tips?
Very similar to Rachel, and my first one is absolutely stay in lane. Don't trespass outside your expertise. Don't start giving fact evidence. Don't become the advocate. Don't assume the role of judge or arbitrator as to which witness is right. Stay in lane is absolutely number one. A second one I would say is, again, it comes full circle to what I said at the beginning, which is I would want to have, it's not so much a tip for the expert giving evidence, but it's a tip for the instructing solicitor and the client, which is to make sure you have the team or whoever has worked closely with the expert with you, because when the expert's in the witness box, you obviously can't talk to them and find out what's going on, and they can help you. And also sometimes things come out of the evidence that you need the team to then marshal new evidence or documents or find materials, and you haven't got access to your expert, but you at least have access to the team. And then the third one is really, which we haven't really talked about, which is what happens if your experts are hot tubbing or witness conferencing in live evidence. That is a very different way of giving evidence, and you need to think about that. If that is what's going to happen, the witnesses are going to be put in together. You need very clear rules and directions from the tribunal as to how that's going to work, whether they're going to be able to have a complete free-for-all or whether they're going to have to be confined to certain issues that are identified in advance, what the process is going to be, whether it's going to start with the tribunal or whether it's going to start with cross-examination by both experts, the order in which you're going to ask. But that takes an awful lot of thought, and unfortunately, when that goes wrongly, it's normally because people have tried to do it at the end and they haven't really done the thought a month in advance as to how it's going to work and what the process is going to be. And it is a very different process to the more conventional cross-examination of experts.
Yes, agree. Thank you for that. I had a case a few years ago where the tribunal surprised everyone with a hot tubbing session after my testimony. He said, "You stay where you are," and the other expert come back and sit, and then take 5 minutes. And the counsel agreed because they had to, but everyone was horrified. And it went badly, but thankfully for the other side, not for us. A couple of points I have from the point of view of the expert is make the best use of them and their team. And in particular, get them to assist you with preparation of the cross of the opposite expert. And this is really where we can add value and assist you. In particular, the follow-up to the responses of the expert. So help them, they can help you in setting out a sort of decision tree, because sometimes you don't know what the answer is going to be exactly. So if they say this, then that's how you follow up. If they say that, this is what you could say. And almost as importantly, make time for that and do it early enough so that you get the full advantage of it. On a couple of cases, counsel was too busy to engage with the cross-examination of the opposing expert until the last minute, so the night before, during the hearing. And needless to say that this technical discussions on DCF or pre-award interest at 4 a.m. are not going to be fruitful. And in one of those cases, the opposing expert got away with a lot more than they should have or would have if counsel had been prepared properly. So do take the time, and also get the expert and their team to review the transcripts and the draft post-hearing submissions and assist you with the relevant parts. Karen, do you have any other tips or horror stories?
I think the main thing for me is to know your report inside out, upside down, revise as if you're revising for a really important exam. Know the appendices inside out, upside down as well. I think that just when you're being cross-examined, then it went fine, but I wouldn't want it to have been in a position of, well, I can't remember what that is, I don't remember any of that. So just know your report really well. I would say, I've seen examples of going back to what we were talking about at the beginning, about making sure you get a hands-on expert, not someone who's left it all to assistants, because I think that really comes across whenever they're being cross-examined if they don't know the detail because they didn't do the work fully themselves. That would be something just again to avoid.
Yeah, agree that there's nowhere to hide. Okay, brilliant. Thank you all. So we got to our final topic and we have 8 minutes left, and that's possibly time for a change. Now we're going to finish with a few suggestions. There's nothing really new here. It's just some techniques that we've seen work and that could either complement or replace the sort of adversarial cross-examination model, or maybe complement them. Why don't we start with you, Karen, and some of the things you've seen work?
Sure. Roberta and I were both talking about documentation earlier. I think one of the key things that's already changing is how we get our documentation that we do our analysis with. Construction projects are vastly different in how they produce documentation these days, and there's a lot more produced. And sometimes as experts, we get given just gigabytes of information, go away and search through that. Sometimes we get given access to people's email, just go away and search all their emails, which takes a lot of time and is really costly. But I do see that there's a lot better technology out there to be able to search documentation, file it in a better system so that everyone knows what they're doing. So that's definitely going to improve things and save time and costs, and that's great. I think another thing that I see, I haven't been appointed as a single joint expert, but I see that happening on occasion, and I think that has lots of benefits potentially. I think it's probably quite a good position to be in as an expert because you don't have any potential pull to one side or the other. You get both sides set of data, so you've got a fairly full set of information to work from. I think potentially there can be negatives with that. Roula has said she's come across some experts who might not be so competent and diligent, and therefore that might work out less well. And the parties usually have to appoint their own experts, advisors as well, so you end up with 3 experts, not 2. Also, I think, Roula, you were saying that in your experience, single joint experts are often paid significantly less than party appointed experts. So again, that might have an influence on the quality of the experts.
Yes,
So, but it'd be interesting to see more of that coming, I think.
Yeah, I agree. We talked about witness conferencing or hot tubbing, so I won't get into that, but that could potentially help things. I'm going to try another apparently controversial suggestion, which I know Rachel and Roberta hate, but I would suggest thinking about having an expert advisor to the tribunal or the court. So that could be someone that's chosen by the parties, that could be someone that the tribunal chooses and gives the parties a right to comment or veto. And this is not an expert who's going to write a report or testify or be cross-examined, so they won't add very much to the costs. But what I'd like to see is an expert just assist the tribunal in understanding the often very different, unfortunately, views of the experts, checking whether their views are consistent or inconsistent with standard practice. And this evaluation makes a big difference, whether it's controversial or accepted in the profession. And more importantly, what the unspoken premises are behind the assumptions. That's often never explained, and you need quite a bit of background to figure out whether the assumption makes sense, because this is what it's based on. And the experts, especially those that are stretching, will never tell you what the unspoken assumptions are or the premises behind them. I think it could lead to better decisions, but without costing too much. And for English practitioners, it's not too much of a stretch or loss of control if you compare that to adjudications, for example, in construction, or expert determinations in valuation or completion accounts disputes. So I'd be grateful for views from our solicitor and advocate. And then finally, bifurcating. So if you bifurcate the damages from phase from the liability, and on the damages phase, you have a damages expert, or you bifurcate, say, the quantum or delay phase, and on that phase, you have a construction expert or experts as the tribunal. That could lead to better decisions as well. And I've seen that done a couple of times, not a lot, unfortunately, and it makes perfect sense. Rachel, what do you think about those new suggestions?
Well, anything that takes the adversarial out of a hearing I tend not to like, because that does me out of a job. But joking aside, the single joint experts, I'm not a big fan, I have to say. I think that the time it takes to draft the instructions, there's very limited, it seems to me, circumstances when they're useful. Possibly one is when you've just got a testing house doing some testing on some concrete samples, things like that. I can see it works, but I'm not a fan. Hot tubbing, sometimes that works well, but again, you've got to pick your topic, and you've got to make sure that there's isolated issues that can be just dealt with in a proper way. So I've seen it done very well with 2 delay experts when they effectively disagreed on 3 out of the 20 windows. So it just made sense just to deal with those 3 issues. But it was done in a very structured way, as Roberta says you need to. We'd agreed we cross-examine each, and then on each topic, and then the tribunal would ask their questions, but it was just that they were sitting together. Quantum, it can work again if there's limited issues. The tribunal, as well as in counsel or the counsel teams, need to just be aware that sometimes there's a difference in approach to cross-examination, as we all know, in the civil jurisdiction and our common law jurisdictions. So the tribunal does need to watch out, because what happens to me on a hearing is that we done it traditionally that you had cross-examination of both of the experts, and then they were going to be sat together for some hot tubbing. But my opponent in that case suddenly decided in respect of one expert, given that the tribunal was going to do hot tubbing, he wasn't going to cross-examine at all my witness, which left the tribunal horrified, because they realised they were going to have to do something to challenge the evidence. So I guess that's it. As to your tribunal appointed expert, I am totally against someone having the ear of the judge or the tribunal without me seeing what they're saying, and without me being able to challenge their opinion, because it may well be that the tribunal's expert thinks that they are right, but they may not be. And that's just one opinion on a spectrum. I know Roberta feels strongly about this as well, so I'll let her say a bit more. I mean, my only experiences of court-appointed experts, which was how it was run in a civil law case I did, meant that the tribunal had 2 experts, but obviously had to be transparent, so slightly different to you. So we ended up with expert reports from the parties' experts, expert reports from the tribunal's experts on those expert reports, and then I had to cross-examine not only the other parties' experts, but also the tribunal's experts. And it seemed to me it was it didn't work particularly. I mean, as it happened, the result was absolutely fine, but I thought as a process it was not satisfactory at all. So over to Roberta.
You've got the last word, Roberta.
Well, it endorses what Rachel says about tribunal experts. It just increases cost. And actually, I think it sows even more uncertainty. As I said at the beginning, my experience is, the more experts you have, the more different views you have. More PhDs, the more different views you have. So I'm not a fan. And I think the proof is in the pudding, right? If you think that this has actually been around 20 odd years with the Wolf reforms, they brought in the idea of single joint expert, and yet you never hear people using it anymore. They've really shied away from it, seeing the cost goes up. And I think the danger, I think judges are pretty strong-minded, so they don't necessarily defer to a tribunal expert, but also I think they don't feel they need it themselves, particularly if you're in the technology and construction court or a specialist court. And I think it's the same in arbitration, in construction disputes where they are specialists. But they're certainly not going to delegate to it. I think maybe some less specialist arbitrators, if they need it, the danger is they're going to delegate part of what is actually their role, which is to decide, and they rely too heavily on it. So I'm absolutely against it, and I would oppose it if it was suggested. To be fair, I have never seen it suggested. It doesn't mean it doesn't happen, but in my 30 years, and I don't think anyone in my firm in the construction practice has actually used it either or seen it used. So it shows you, I think it was a good idea, but not in practice. On the other points, and I'm conscious of time, bifurcation, again, I have never seen it work well. I've seen, I think it's a sort of a worse than a preliminary issue, right? 2 trials are always more expensive than 1. If you want, 1 and 1 to equal 4 in costs, bifurcation is the way, and it becomes a nightmare. The lines of demarcation are never clear, they're always blurred, and so you get lots of unintended consequences. It doesn't shorten things, because what ends up happening is the party who doesn't like the decision recasts its case to take it into account. The party who's been successful recasts their case to bank even more than perhaps was intended, and the tribunal has its hands tied in phase 2. So it just doesn't work. It's increased cost and almost guaranteed to derail the whole process and make your hearings more expensive and much longer. So, like the cases say about preliminary issues, resist that siren call of bifurcation. But one thing I have seen, and it's seen only recently in the sense in the last year, which I thought was a very interesting idea, was the tribunal directed that there should be equality of arms between experts. Very early stage, it said that anything that you allowed your expert to see, not just rely on, but to see, had to be produced to the other side. Now, the theory behind that, and if it's done properly and with in good faith, is a good one, right? Because both experts see absolutely everything, and there isn't any hiding or nasty surprises at the end, and they can give you a truly independent view looking at everything rather than just your side's documents. Unfortunately, if one side doesn't behave, what you get is they're obviously quite careful what they give their expert sight of, and hold it back until quite late. So I think it's a really good thing in theory, and if both parties engage in it with the right spirit, I think it has real legs to make sure that there is equality and document production is early when everyone's doing the investigative stage, rather than having the scramble of disclosure just a month before witness statements and 2 months before expert reports.
Yeah, I agree. I've seen horror stories with asymmetry of information between the parties, and one expert having information that the other one doesn't have and only sees after their report. So not good at all. It's a shame you didn't like my suggestion, but there we go. Thank you so much. I'm sorry, there are a couple of questions, but we haven't had a chance to answer them. So if we haven't, then please join us at the HKA networking table in the networking area. And it remains for me to thank our panelists very much for their brilliant contributions, even if some disagreed with me. And thank you all for joining us again, and enjoy the rest of LIDW. Thank you.
Thank you.